Hi, everyone. If you've just joined, thank you so much for being part of today's session, which is focusing on changes to the Constitution. And I think what the session is called um, is, let me get the exact wording. Um, oh, I can't see the wording, but major changes to the Constitution and whether that constitutes democratic reform or anti-constitutionalism. We have a really great speaker lined up, and we're really excited to get going. But we do just want to allow a little bit more time for people to join. So we're going to ask that you just give us 2 more minutes, and we'll start promptly at 3:05. Thank you. Yeah, I think we're ready to begin. Afternoon, everyone, and thank you for those of you who've been following this and other webinar series hosted by Defend Our Democracy. Thank you for returning, and we hope that today's webinar will be as fruitful and as engaging as the last couple that have been hosted. But today we have a very relevant, I think, a nuanced topic, and it requires us to be critical about how we think about things, and I think to be able to hold space for differing views, but then on the foundation of what our foundational values are as a country and what the Constitution and I guess what the spirit of our country requires of us. But it's I think not black or white, and I think there's a lot of gray in the topic that we're talking about. You would have known by signing up for it that we're going to be talking about major changes to the Constitution, and whether we see that as anti-constitutionalism or as democratic reform. And maybe the answer is not as clear cut as one or the other. There may be elements of both. There may be elements of neither. But we're talking today to Mbeke Zeli Benjamin, who is very learned in the subject. Mbeke Zeli is currently, I think, a research and advocacy officer at Judges Matter, and is based at UCT. Is it UCT
Yes, at
in Cape
UCT.
Town? At UCT, and he's had a career that has been spanning decades in public interest and human rights, journalism, and providing expert commentary on issues related to the judiciary, but also to realizing human rights in South Africa and to democracy more generally. Um, we Just some things from his bio is that he was listed in the Mail and Guardian's top 200 young South Africans, and he was also Stanford Law School's youngest global practitioner in residence. And I think he lectured for a couple of courses there at Stanford Law. So we're really, really happy to be chatting to you, Mbeke Zeli. Thank you so much for making the time. And yeah, and I know you're busy, and I think you're currently not even in the country, but we're so happy to hear from you. I think what's a time in the country where people are grappling with many things, and just more generally globally, you find yourself feeling almost excited about things you shouldn't be excited about, or um everything is kind of shaken up, and we're confronted with so many things daily, both globally and nationally. And so if you can provide some sort of light and some clarity on some of the questions that people might be asking themselves in relation to the country, I think, yeah, that would have been a good webinar then. So over to you. Everybody else will just ask that you remain muted, and then we will have a question and answer session following Mbekezeli, and you'll be free to ask your questions there. So just hold it till then and enjoy.
Thank you very much, Kristen, for that very generous introduction. I haven't really been here for decades. I've really been in law for just the last decade or so, so still a bit too young to have spent decades, unless I started from birth, which I didn't. But I really do appreciate the invitation, and I do appreciate people spending time to chat with us, because this is a conversation. I'm hoping that I'll add a little bit of input, and then we'll get a lot more interaction as the conversation unfolds. But I'd also like to thank Defender Democracy for inviting me and for convening us in this space. So really, really thank you to you, Kristen, and to the team, Zinzile and others. I appreciate it. So the topic that I was given to chat about is major changes to the Constitution, and specifically whether this constitutes democratic reform or whether it's anti-constitutionalism. And I think, Christian, you've set us up a little bit by saying it might be a bit of both. And I agree with you. It is a little bit of both, but we really need to keep our eyes open as to what is going on and what it means, and why do we think it is a bit of both. And so I'd like to structure my opening remarks around a few questions that I asked myself in thinking through this topic. The first one is, I started off from a very personal perspective, is what does the Constitution mean to me? And what has it done for my own life up to this point? The second question is, what am I seeing in our country in terms of the evolution of our constitutional structure, our constitutional reality? What does that look like? The third one is, what are we seeing at the moment in terms of the kinds of changes that are being called for, the kind of criticisms that are being made against the Constitution, and what does it mean for the future? And more importantly, what should be the role of democratic institutions like the judiciary, and for some of us who are in civil society, what should really be our role in this conversation? So I'll structure my few remarks around those questions, and then hopefully that will also invite more comments from the rest of the audience. So starting off, what the Constitution means to me, I think I am a constitutional being. I am someone who's lived under the democratic constitution, and I've been a beneficiary of some of what is good in our democratic constitution. So I was born in 1992, very close to our democratic elections and our democratic transition. And I don't want to say I was born or I grew up post-apartheid, because the legacies of apartheid live with us till today. So I don't think that we are 100% out of it. But yes, I grew up really in the democratic movement, in the democratic South Africa. And so I am privileged in that regard. And what that has allowed me, and perhaps to start off, what my first real thinking about the Constitution and what it means, it was actually in primary school. At the time, I went to school in Soweto. I'm from Ezondi, which is a small corner of Soweto, and all my schooling has been Ezondi. And so when we first started speaking about the Constitution, it was in primary school, where we were introduced to the Bill of Rights, and specifically Section 28, which is children's rights. So children have a right to a name, to a nationality, to food, care, and all of those. That was my first understanding of the Constitution. And then later on, I think the most vivid memory I have of the Constitution is when we went on a visit to the Constitutional Court in 2004. The building was still under construction, but we were taken on a tour of the old Fort Prison. And that really stuck to me, because that was my first encounter with what was described as the brutality of the apartheid system. Old Fort Prison is, of course, the prison where Nelson Mandela was imprisoned, where Mahatma Gandhi was also imprisoned, and so many other political activists were imprisoned. And we went on a tour, and we were pointed out that the bricks of the Constitutional Court were actually the bricks of part of the demolished prison facility. And so what that told us is that the Constitution and the Constitutional Court are meant to be institutions that serve a democratic and free South Africa, but they're really, really based on and are built on the legacy of apartheid and colonialism and the brutality of it. So for me, I still view the Constitution as that. And Professor Etienne Morenik, who was a constitutional scholar, described it as the Constitution is a bridge, right? It's a bridge from our brutal past to a more egalitarian and prosperous future. So that for me, that tour in 2004 vividly illustrated what I later learned Professor Morenik described our constitution to be. And on a more personal level, we were taught at school that we have a school nutrition program, which is what we call a school feeding scheme. And that was because the government had an obligation to us as kids to provide for us while we are in school. And so we were taught the Constitution also was touching us in that place. Later on, of course, I went to university at Wits, and I'm a beneficiary of the National Student Financial Aid Scheme, so NSFAS. And again, that was an obligation that the government was undertaking under the Constitution to provide access to further and higher education to some of us who would otherwise have not been able to if that wasn't the Constitution at work. Of course, I did law, and I was taught constitutional law by a number of really, really excellent scholars. And one of them that I can highlight, there are several that I can point to, but one of them was the now Judge Stuart Wilson. He taught us property law, which, if you know property law, it's traditionally based on Roman Dutch law, and it's supposed to be these dry principles that have really existed for centuries. But what Judge Wilson did was he emphasized the people at the center of property law and the impact that the Constitution has on an ancient legal system like property law. For example, the traditional conception of common law ownership is that the owner is king. The owner can do whatever they do want with property, and there is no constraint to what they may do with the property. But the Constitution introduced certain rights for people who are not owners, people who are just occupiers of land. And some of those rights are contained in Section 25 of the Constitution. Some of them are contained in Section 26 of the Constitution. And what that means is that if I'm an occupier of land and someone is a private owner of land, that I cannot just be kicked out. Section 26(3) of the Constitution says that I may only be evicted if it is just and equitable from that land and after a court order. So what the Constitution does is that justice and equity is now a factor to how someone exercises their rights as the owner of land. And so what that does is that it actually, the Constitution, it creates new forms of rights to land that have not really been in existence prior to that. And so what that does is that it gives people who otherwise would have been marginalized. It's often, when they were writing the Constitution, the drafters of the Constitution, what they had in mind is people who in the apartheid were simply removed from land. And we think here about people in Sophiatown, people in District 6, in other cities where they were simply removed without any statutory protection, without any legal protection. It was just by decree. So what the Constitution does is that it does protect people in that way, but it continues to offer that protection to way more people than even those who own property or who are displaced or whose land or property is confiscated. So that, again, is another example where I was really woken up to the idea of the Constitution at a very personal level. And that also ties in with the community that I grew up in, right? Because we were in a township, we knew that there were some people who lived in brick houses, we knew that there were some people who lived in shacks, and those who were in brick houses had more rights and more protection than those in shacks, because those in shacks could be removed at a whim. And so for me, that also concretized the idea of the Constitution. Later on, and that's where the decades come in, Christian, is that I worked in civil society, in the public interest legal organizations at SERI, where we did housing at Equal Education Law Center where we did education. Again, for me, the Constitution meant that I could use my own skills in order to ensure that there is equality and equity in housing and in education. So for me, the Constitution is a very personal thing. And so through my own personal story, I've sort of touched on what the Constitution has done for me. And so I place a very high premium on the Constitution. But I do so still with a very real sense that the Constitution is not, in as much as it might feel like I'm treating it like a Bible, I don't believe that the Constitution is similar to a Bible. I think the one common difference is that the Constitution can be changed. The Bible maybe it can't, I'm assuming. For religious people, they'll tell you very clearly that you can't change the Bible. But the Constitution is meant to be changed. It's meant to speak to the realities of people. And that is an important thing, right? The Constitution itself mandates that it is changed. It is reviewed on an annual basis. We look at, is the Constitution working? Is the Constitution delivering on what it's meant to deliver? Is it addressing the injustices that are meant to be addressed that are from the past? So if you read the preamble to the Constitution, it says that we must, as a society, address the injustices of the past. So if the Constitution itself mandates a review, a reconsideration, a serious grappling with what the Constitution is doing in our society. And that is an important thing, because if we're speaking about changes to the Constitution and reforms to the Constitution in our democracy generally, we need to be thinking from what the Constitution says mandates us to do and what we can do and what we should be doing versus what I think is a populist narrative that is going around in society about how we should really throw out the Constitution and put something else in place. And that is something that is gaining in popularity and we need to be grappling with. But back to some of the changes or the reforms that are contemplated. First and foremost, I don't believe that the Constitution is something that should be revered like the Bible. It's not something that it should sit there as an ornamental piece. It is meant to do something. For me, the Constitution is very utilitarian. It is a tool towards an end. It is a tool to transform society. It is a tool to build a democratic, peaceful, prosperous, egalitarian society in South Africa. It is a tool in the hands of the most marginalized people in our country. It is a tool for protecting our liberties, our freedom that blood was shed over. It is meant to do that. So if it continues to do that, we must jealously guard the Constitution. If it is no longer doing that, we must change it in order for it to achieve those aims. So for me, that is what I see the Constitution as. And when I think of changes to the Constitution, I think of them in that framework. And then secondly, and this is again going back to the title of today's talk, which is democratic reform. The society that the Constitution envisaged is that we must have a vibrant democracy. We must have a democracy where all of us, no matter our station, no matter how wealthy we are, no matter how poor we are, whatever our gender, our color, our race, or any other identity marker, we must be people who are dignified, who are living in a free society where all our rights are protected and respected, where government, if it owns our obligations to us, those constitutional obligations are fulfilled, but also it protects us from even corporations. I mean, the Constitution, South African Constitution is extraordinary in the sense that it has something what is called horizontal application. Ordinarily, most constitutions around the world, they have what is called vertical application, where the state and the citizens, that's the Constitution regulates that relationship. But our Constitution goes further than that. It regulates even and protects us even from private power, from corporations. I mean, the right to privacy, for example, it protects us from even corporations going into our data and stealing our data. That is something that is, I think, unique about the South African Constitution, because if you read the privacy protection in other places in the world, usually, and if you think about the United States, that constitution only goes as far as to stopping government from surveying you or spying on you. It doesn't really give you a right not a right to privacy. That means your data, any other of your personal information is protected. It doesn't go that far, but ours does. And so it does even go that far as to protecting us even from private actors and private power. So that is something that we must also keep in mind when we're thinking about the South African Constitution. And when we are thinking about the Constitution and what it should look like and the democratic reforms, of course, there are things that the Constitution says that the state, for example, must do in order to fulfill the rights and obligations in the Constitution. But there is often a refrain, and some of the criticism that you hear about the Constitution is that the Constitution is not doing stuff, is not doing certain things for people. But the Constitution is not necessarily meant to do stuff. The Constitution at the end is a piece of paper, and that is important. What the Constitution does is that it sets out our aspirations as a society and sets out responsibilities and obligations on the state, for example. So when we are frustrated about, for example, the land, and I was listening to a debate in Parliament yesterday that the Constitution has not given people land and is actually an obstacle to people getting land. I always scratch my head because when I read Section 25 of the Constitution, which is one of the longest sections of the Constitution, by the way, that section, it is so revolutionary in my view. It is revolutionary in the sense that it goes from, on one end, saying that, well, number one, it doesn't protect the right to property, which is important, an important distinction from other constitutions in the world. It doesn't protect the right to private property. What it does, or it doesn't actually give you the right to private property. What the Constitution does, it says your property may not be arbitrarily deprived or taken or deprived. And that is it's a shield. It's not necessarily a sword that you as a private property holder can wield against other people. So the Constitution protects you, but it doesn't really recognize the right to private property. But it goes even further. It says the government must take steps for people who have unsecure land, whether it's labor tenants, whether it's people who were farm workers, people who don't have access to land. It says even the Section 25(8) says if you don't have equitable access to land, the state must take legislative and other measures to provide you with access to land. So what that tells us is that yes, it does mention 1913. The Constitution does say that there must be restitution of land for those who were deprived from 1913. But my reading of the Constitution is that it goes much further than that. Even if you weren't a victim necessarily, a direct victim of the 1913 Land Act, you still need to be provided equitable access to land. And that is an important thing if we're thinking about urban areas, people living in informal settlements in our cities. Those people don't have equitable access to land. The Constitution says that they must be provided with equitable access to land. There's the right to food and water, the right to healthcare, social assistance, and all of those rights. They are there in the Constitution in order to advance this egalitarian society that the Constitution envisages. So again, when we hear some of the criticisms around the Constitution, some of it does relate to the Constitution. There are people who have made legitimate criticisms about the mechanics of the Constitution, for example, its concentration of appointment powers in the hands of a single person, which is a president. Those criticisms, I suspect, are legitimate. There are certain parts of the Constitution, for example, impeachment. When you're impeached, what are the consequences? The Constitution doesn't really give the details. And so that is something that I think is a flaw in the Constitution, and we should take that criticism seriously. But again, making the example with the land, there is a lot of criticism that we hear that is simply not informed by what is either in the Constitution or what should be the role of the Constitution. There's a lot of frustration with government failure, with policy failure, with decisions that are made by Parliament and the legislature in order to implement the Constitution. But that is not a problem of the Constitution, it is the problem of the legislature. I mean, most people speak about willing buyer, willing seller. willing buyer, willing seller is nowhere in the Constitution. But it was a policy that was made by the government. And so when you're making a criticism of government policy and you say it's the Constitution that says that, then we need to take you seriously and look at the text of the Constitution and whether that criticism is actually informed by it. There's now a new phenomenon that says the Constitution concentrates too much power in the courts and the judiciary under the principle of constitutional supremacy. And what we should actually be doing is to have parliamentary supremacy. That is, Parliament must now be the final word on all things constitutional. Well, luckily, we do have an example in history of parliamentary sovereignty, which was under apartheid. And we saw the outcomes of that, right? And so the reason why we said constitutional supremacy is because we were moving away from the tyranny sometimes of Parliament and it having an unbridled power under the Constitution. In the UK, they do have parliamentary supremacy, but in the UK, they also have directly elected representatives, something we don't have in South Africa. So I often hear, and this comes from one particular party, not sure if I'm allowed to mention that political party, and even last week in Parliament, they were saying we should move towards parliamentary supremacy, which is funny because none of the people who are in Parliament today representing that political party were on the list of that party before the elections. So actually, they were not even elected by the people who they are now saying that they should be the ones who have the final say over. So those kinds of criticisms we also need to be aware of, and we need to interrogate in what they mean, because often they are ahistorical and acontextual. So what I'm saying is there are legitimate reasons why we should be thinking critically about the Constitution. We should be thinking about what kind of reforms and changes that we should be making to the Constitution. But we should also be mindful and alert to some of the what sounds like very good sound bites and sound clips in the media and in Parliament and in the speeches, but they're not informed by what is in the Constitution or what the Constitution actually is meant to do. So we need to keep an open mind to that. And this is not to say that it has really been kumbaya under the Constitution. Like I said, we still have frightening levels of inequality, frightening levels of joblessness and poverty. We still have extreme levels of violence in our country. And we need to be thinking critically about what that means under the Constitution, because Section 12 of the Constitution does provide us freedom and security of the person. But if we are daily subjected to violence. If you are a woman in particular or a child, you live daily stalked by the fear of being raped and killed. And so what does that mean in terms of your constitutional right to freedom and security of the person? So those are the things that we need to be thinking carefully about. And if that is the source of the criticism, we must address it. And to quote Tembeka Ngcobo, is that we must take those kinds of criticisms seriously about our constitutional structure. But at the end, we must remain critical and we must be wary of people who, I don't want to call them demagogues or populists, who want to hijack a serious conversation about constitutional reform, and they hijack it for their own purposes and their own means. And just to also end off on a point, I was listening this morning to the Programming Committee of the National Assembly, and one MP made a point that he's frustrated about how long it takes for Parliament to pass legislation. Ironically, that MP comes from the party that is pushing for parliamentary sovereignty and instead of constitutional supremacy. It's ironic for me because it is the Constitution that requires for Parliament, before it passes legislation, it must consult us as the people. There must be hearings, there must be public participation, there must be input into that. And in fact, it is the Constitutional Court that has set aside legislation, acts that have been passed by Parliament, for them not having sufficient public participation and consultation, even though they were passed by a democratically elected Parliament. So in essence, what this MP is expressing frustration about is something that is valuable to us as citizens, that we must be consulted on the laws. What he wants is that it should be like America, where you introduce a bill on Monday morning, and Friday afternoon that bill is passed. And that is not what should happen under the South African Constitution. And so, in some ways, the Constitution is even protecting us from those who hold important positions in our parliament. And so that is also something we must keep in mind. And lastly, sorry, I want to speak a little bit about the role of other institutions. I mentioned the judiciary, that the judiciary does play a very important role in interpreting the Constitution and helping enforce the rights and obligations under the Constitution. But the judiciary is also not a law unto itself. It does not mean that the judiciary has a free or a blank check in order to do anything and everything under the sun. The judiciary has a responsibility, for example, to respect the authority of parliament. They have a responsibility to respect the authority of the executive in the responsibilities that have been assigned to the executive under the Constitution. And the judiciary has a responsibility of self-restraint, first and foremost. Judges must restrain themselves and they must only follow the law. And when they don't do so, there is a constitutional provision that says that they can be set aside or overruled on those specific issues. But there's also a role for citizens to hold democratic institutions like the judiciary accountable. I mean, that's what we as judges better do on a daily basis, is that we realize that this institution is so important in our country and under our constitution that we can't really leave it for it to watch itself. We are there to watch it, and we are there to even urge Parliament to watch over it, because that is how the Constitution designs our structures, our institutions, is that they must hold each other accountable. They are independent but interdependent, and they must, under the separation of powers principles, hold each other to account under the Constitution. And that again is something that we as in civil society must be playing a more active role in doing. So with those few remarks, and I'm really sorry for the long speech, Kristen, I'll end there and I'll be happy to take the questions.
No, not a problem at all. It wasn't even long. It was very enjoyable. Thank you so much, Mbekezeli. So maybe let me just start off with a short response. Thank you so much for sharing about your own personal experiences of constitutionalism in action. I used to work at the Legal Resources Center, and we were based at Constitution Hill. And something that I think we, the people, in collaboration with, I think, the court, or specifically Justice Majid, but other justices as well, are doing, is this program around training young people in schools about constitutionalism and about the Constitution. And so on that day, they brought a number of young learners to the precinct and let them meet some of the organizations that were working there. And I mean, it's 2026, and people are still having the same experiences. One of the young girls said to me, she never understood everything that she learned in school about race and about apartheid and about our country and about democracy, but it became so real for her. And she was feeling all sorts of emotions like anger and, hatred, and then thankfulness and gratitude. And it's such an important thing, I think, for not only young people who this can seemingly pass by, but for all of us to be constantly reminded of. Is my audio off?
Yes, we hear you very clearly,
Oh,
Kristen.
okay. Okay. Sorry, Mbeki. And I think it's so important for all of us to be reminded of our own personal experiences and our lives that have been shaped by the political framework of our country. So the fact that we have a constitution now and what that means and what that entitles us to, and for many people in this room and in our country, that would look starkly different to a pre-constitutional dispensation. And then
And
just to
on
say,
that point, sorry to jump in, Kristen.
no
On that
problem.
point, I mean, it's a pity that in 2026 we don't have a distribution of copies of the Constitution in all 11 official languages.
Mm,
And that was a program that was meant to also address constitutional education, right? We
yes.
must know, we must understand the Constitution, and there should be many more kids who go to any part of South Africa actually has you can clearly see how the apartheid system worked, the oppression under apartheid,
Yeah.
and what in our democratic society should be. And so we do have touch points for the Constitution, and there should be that kind of level of constitutional education. And I really, really, I regret that we don't do enough of it.
Yeah, and I think that is part of the problem that we're facing now, is that not only with young learners who are coming through the education system at this point, but just for everybody who older people who weren't in school when the Constitution came about. What is their constitutional literacy like? Do people understand, like you're saying? I was taught by Stu Woolman, and he describes the Constitution as scaffolding, as it's just supposed to be this thing that outlines what's supposed to happen, and it gives both powers and obligations, but then it's a political will issue about how that's implemented and how that's done. But do people in our country have literacy about the Constitution and about its importance, also about how it functions, and what is a constitutional issue, and a defect in the Constitution versus a political issue, and a defect in our politics or in how things are implemented? I think are different things that we need to be grappling with. And I think on that note, while you were talking, I was thinking about, because I agree with you. I think it's so important for us to be critical and to be able to discern between when the Constitution is necessary to be changed because it's not serving the purposes that it says it's supposed to serve, um, and when people are exactly hijacking a legitimate conversation about legitimate reform that needs to take place, for ulterior agendas, right? And something that I was thinking about is when we would see in the news recently people celebrating things like extrajudicial killings, because of their frustration with crime in the country, and because there isn't enough being done to solve the crime issue. So you get these sort of anti-democratic narratives which are then celebrated. The same thing around people's socioeconomic circumstances, which I think lends them to being susceptible to anti-democratic narratives, and to being plagued with these sort of things. And so that's the reality that we're in, right? That people aren't just being taken by these ideas about that present themselves as something that will pay off and help in the long run, but are, as you rightfully say, are a hijacking of a legitimate concern. But people are vulnerable and they're susceptible because of where we are in the country at the moment. So yeah, sorry, I don't know if that there's no question in
Yeah.
that. I just wanted to
No, no,
say
no, no.
that.
I think you do raise an important point. I do not believe that being poor means that you're stupid, or being poor means that you do not understand what is going on in the country, or you don't understand what our political system is like. And yes, maybe it is a situation where we do have people who are wanting to hijack our political system and genuine narratives. I mean, and it's not even a South African thing, it is a global phenomenon. We are seeing what is called democratic backsliding across
Yeah,
the world, even in advanced economies, where you see, or advanced democracies, older established democracies, where you see people offer easy narratives to people's genuine problems. They say, look, it is the fault of this person or that person, whether this person is a foreigner or whatever identity that
yeah,
they are. They are the cause of your problem. And that is something that we see on a day-to-day basis. And it's not a question of poverty. So that is not something that we must sort of attach, that if you're poor, then you can sort of be hijacked. I think where the gap is for us as a country is not really grappling with what this constitution is really, really meant to do, in the sense that and you're right when you quote Professor Stu Woolman saying it's a scaffolding. It is a scaffolding because it's supposed to provide a structure for how our society should function. And then we should be coloring in or filling in what that actually looks like. I mean, right now we are going up to local government elections, right? And people might not necessarily make the connection between the roles and responsibilities constitutionally of a municipality versus what should the national government or the provincial government be doing, right? And that is something that we should then be coming in and saying, look, the constitution says, for example, the municipality is responsible for water, electricity, roads, parks. Your province is responsible for healthcare, for education, for social development, and then the national government is responsible for other functions. So even though you can express your frustrations about a national government politician, but when you're thinking about local government, they have a different constitutional responsibility. And similarly, when you're thinking about local government and the not having water in your community, your person that you should be going to, yes, is the local ward councillor, and people do, I think, know that very well. And then but where we're not really making those connections enough is that the municipal council as a structure is the one that is primarily having to step in and supported by the other structures of government. So that is something that is a conscious education that we must filter into our communities so that when people do have genuine frustrations with service delivery, they should know how to channel them and how to exercise their rights in a way that is responsible. So it is a constant project. It's I don't think that the constitution has a termination date because it's a project that is ongoing. And what we're learning from countries abroad is that it requires eternal vigilance. You can't reach a point where you say we are cool, we are sharp, our constitution is perfect, nothing more needs to be done. It can easily go the other way. You speak of extrajudicial killings. In the Philippines, thousands of people were killed, thousands of people were imprisoned in what was the president was calling the war on crime. And that was populist and which was good, and people were frustrated by crime. But the
Yeah.
other end of it is that he could very easily erode all of the rights that people had,
Mhm.
and it ended up harming innocent people. And that is where we don't want to be as a society.
Yeah. Yeah, thank you, Becky Zeli. There's a couple of questions in the chat. I'm gonna read them to you, and then if anybody else wants to ask some questions, please feel free to put your hand up. Maybe just as a response, just to say, I'm sorry. I definitely didn't mean it around people's socioeconomic circumstances, meaning that they can easily be hijacked. I was reading something today by Sandra Liebenberg about reparative justice and socioeconomic rights, and I think continuing patterns of inequality and oppression affect certain races or certain socioeconomic groups. And where those things aren't resolved through the constitution, or through political will in implementing the constitution, people become desperate. And I think that's a fair position to be in, to then be not necessarily hijacked about what political system you may be subscribing to, so whether it's parliamentary sovereignty over constitutional supremacy, but about which political party to vote for. Because if somebody is promising you something that you're not currently seeing, and you thought through the constitution you would have access to, then maybe you'd be a little bit more swayed to believe what they are saying and where the problems lie than someone else. But I mean that, and I think you're right, that cuts across class and race and gender. But I think those identities do play a role in how we perceive things and how we are able to be convinced of certain things and what we believe as well. Okay, so there's a question here that says, not related to this webinar, but would you be able to comment on President Ramaphosa's delay in appointing judges to the Constitutional Court and the impact on the performance on the court? I'll maybe let you leave that one for the end. I'll just bring two of the others that have to do with the topic at hand. So the one says, at what age should constitutional education start? The other one says, could you talk a little bit about administrative justice? People complain every day about service delivery and also in government departments and in the private sector. How does the Constitution assist people in ensuring admin justice? And then I think one more, because these are just small ones. You've raised a very good issue, although you may be missing a point where he indicated that some of the delays may need to be dealt with while taking into account not to degenerate to the American way. You're dealing with serious issues that affect the society at large. He gave an example of creating a bill in the morning and it is passed the following day. I think that's something which we have to be cautious about while taking into consideration the unintended consequences. I'm not too sure what the question is there, but I think maybe that's just more of a comment. So maybe if you can just talk to the administrative justice one and the constitutional literacy age, and then maybe just about the appointment of judges.
Thank you very much for the questions. Well, in my view, Solomon, the constitutional education starts from birth, because from the time that you are born, you have constitutional rights that endow on you, that you automatically assume just by the fact of your birth, right? For example, from the time you are born, you have a right to a name in terms of Section 28 of the Constitution. And so and you have a right to family care and the like. So if you're not being cared for as a child, that is already a constitutional violation and you need to be aware of. And maybe the question is, what is the age-appropriate ways to teach the Constitution? And that for me is something that I think is something we need to grapple with, and we need to come up with ideas of how do we teach our kids about constitutional rights and also responsibilities under the Constitution, right? Because the Constitution is not only a rights-based document. There are some responsibilities that are implied. That, for example, you must have your dignity respected, but you must respect the dignity of others. And so how do we teach kids around those rights and responsibilities under the Constitution? Our kids, I want to say nowadays, but I do think that in all time, kids have been aware about how authority works in society, right? In the home, mom and dad have authority over you as a child. Similarly, they see what is happening in society. They know what the president, they know, some of them can even name who the president is. And so when you're teaching them about the Constitution and the powers of the president, you can do so in a way that is relevant to them and their level of maturity as children. So there are different ways. And in fact, in my other capacity, I am part of Equal Education. And Equal Education, our main core value and core mission is to activate the agency of young people. And we teach them the political economy of South Africa, which is, where do we come from? Where does activism around education come from? What is the history of it? Why do we have inequality in education? And how do we use the structures that are provided for under the Constitution and the law in order for us to advance education? So that is something that young people, high schoolers, can easily buy into. So there are ways and means. And then just to jump on the other question about administrative justice, of course, Section 33 of the Constitution is the core right for administrative justice. And Ella is asking, how does the Constitution assist? Well, the Constitution firstly sets up different structures. The public protector is one structure that is supposed to ensure administrative justice, because if you look at the powers of the public protector, is that if there's been a failure of administrative justice in the state, the public protector can intervene and protect that right. So the public protector is the lead institution. There are other Chapter 9 institutions, but even Chapter 10 of the Constitution sets out the principles that public officials must adhere to in serving us. And some of it have been articulated in what they call Batupile principles, but that comes from Section 195 of the Constitution. So there are various ways in which the Constitution protects people. But like I said, at the end of the day, the Constitution is a document. We as the people need to make it live. And we do that by activating the agencies and the entities that are of the state, but also taking a very active role in ensuring that. And then the other question was about President Ramaphosa's delay in appointing judges of the Constitution. of the Constitutional Court. I've written about that, I think News 24 last week or 2 weeks ago. But yes, we wrote to the president earlier this week to say that he essentially, by him not appointing judges for 5 months now, he is in violation of Section 237 of the Constitution, which says that every constitutional obligation must be executed or fulfilled without unreasonable delay. And so we believe that he's taking too long, and that is a constitutional violation. And we've called for him to act to fix that as quickly as possible. Over to you, Kristen.
Thanks, Mbekizeli. I'm not going to say too much more because there's a number of questions now in the chat and a hand up. So let me just take this round of questions, and then Kyle, I see your hand. So Sam says, don't we have too much written into the Constitution? And is the emphasis more and emphasizing more on freedom and rights than civic responsibility? Gilda said, there's a lack of political will and at the same time a lack of knowledge of the people. This leads to huge frustration and so many twisted paths to try and get satisfaction. Could there not be dissemination of information to all age groups, not just learners, in various ways and through different channels? And then I think these are also can go into this round. How the the question says, how should the Constitution be implemented vis-a-vis South Africa and the continent? Yeah, I'll leave you to interpret that question as you like. And then Mike says, Section 45 mandates Parliament to establish a joint committee to review the Constitution annually. Do you think this committee is a sufficient mechanism for keeping the Constitution dynamic and responsive to changing needs? Or is there a case for a general review of the whole Constitution every 10 or 20 years? So let me stop there. And then there's Kyle and then two other questions. But maybe let me stop there and give you a chance to respond. Oh, I think you're muted. Sorry, Mbekizeli. Sorry.
Sorry, yes. I was responding to Sam Bambo. I don't think that we have too much written into the Constitution. I think there could be more, but yes, our Constitution is much more detailed than most others, but that is not necessarily a bad thing. And yes, I think the reason why the emphasis in the earlier years was on freedom and rights was because of the trauma. I think it was a trauma response to the injustices of the apartheid system, where there were no rights, or people's rights were not respected, and certainly people's freedoms were not respected. So teaching people about rights and freedoms was important. But yes, they are civic responsibilities that we have under the Constitution, and in other ways, right? We can interpret parts of the Constitution to inculcate this culture of responsibilities, right? If you have a right to education, what does this mean for you as a student? What should you be doing in order to ensure that this right is meaningful and enhances your dignity and reinforces other rights in the Constitution? So yes, we should be teaching more civic responsibility, but I don't think that there's too much written into the Constitution. And then the second question by Gilda about the dissemination of information. Yes, I spoke about it earlier, that it's a real pity that nowadays it's very hard to find a written copy of the Constitution in Chivenda or in isiXhosa or in Setswana. That's because the Department of Justice doesn't seem to be distributing them as much as it did. And so, yes, we should be disseminating constitutional information to lots of different places. There are certain radio programs on different radio stations where they do speak about the Constitution and what it means. I mean, recently there were lots of marches, especially in Durban, about what does the Constitution say about the right to education? Do children of illegal foreigners have a right to education? And people were speaking about that issue. And for me, the message that I got from some of those discussions, and for people who were explaining the true meaning of the Constitution, is that, for example, a child comes into South Africa through no fault of their own. The parents bring them here. They didn't choose to be here. So why should we deny that child an education? There are certain rights that are for citizens. There are certain entitlements that are for people who are living in South Africa, residents who have permanent status, for example, and those who don't have permanent status or any status of at all in the Republic. For example, foreigners generally don't have a right to social security, social grants, but there is a category of foreigners who are entitled to social grants, and those people are asylum seekers. So people who've come to South Africa and the Department of Home Affairs issues them with an asylum seekers permit or a refugee permit, then they can access those kinds of entitlements under the Constitution. That kind of conversation is a conversation that we should be having more, and we should disseminate information about the Constitution through those kinds of things. And then there was a question about how the Constitution should be implemented vis-a-vis the
I
continent.
feel like you kind of also answered that in the last
Oh,
answer. I think that's
yeah.
that's what it was
I,
about.
I I wasn't sure. And then Mike asked about whether the Constitutional Review Committee is an effective or sufficient mechanism. Mike, I think the the Constitutional Review Committee has not really lived up to its full potential, right? Because often they just call for review amendments, and then there's never time to process those amendments. And I mean, even now in the seventh parliament, the first order of business was to look at amendments that were proposed in the last parliament. And that means they were never attended to. And the way that the committee itself functions is that it doesn't seem like a very serious thing. And so Parliament itself is not taking that responsibility seriously. So I think even if we put a 10-year review, I don't think it will yield the kind of outcome that we want. I mean, an example of this was the high-level panel by Kgalema Motlanthe, where he and his panel called for all kinds of submissions. They did some really excellent work understanding what the Constitution has done in the 20-year period since 1994. And that was a valuable exercise, but its recommendations have hardly featured in discussions in Parliament today. So we can make it 10 years, we can make it 20 years, but if the review process is not going to yield outcomes, then it doesn't. I don't think that it changes much, and it's an important process that should really be engaged with very seriously by Parliament, but by also citizens. And then the other,
Bekizeli,
oh,
just before you go to the other question, sorry. The reason that I'm just wanting to do this is because Kyle's hand went up, Kyle Jordan,
oh,
a little while ago. So I just want to give him an opportunity to ask his question, unless the hand is up by mistake.
Thanks, Kristen. I appreciate that. Just 2 points I wanted to make briefly. The first was in relation to the point you raised about the levels of constitutional literacy amongst our youth, or amongst people that aren't in the legal fraternity generally. And I just wanted to say on that that I have for quite a while been grappling with the idea of introducing a subject into the South African NSC curriculum, and that would be Introduction to Law, where you could grapple for 3 years with more basic concepts like subsidiarity, constitutional avoidance, um, just history of South African law, etc. And I think that would do a great deal for many people, not just learners who decide to go into law thereafter, but just for a general understanding. So, for example, if you see a headline that the Constitutional Court refuses to hear the application of the MK party or whatever, you don't think that it was just a choice based on who's involved not to entertain it, but you actually realize that there are reasons, and that there are issues like jurisdiction and standing, etc. That's the one point. And then the other point I wanted to make, Mbekizeli, you know my views on this given our discussions last year, but I do think that many of South Africa's most pressing crises, so corruption, inequality, violence, weak service delivery, all of those things, I do think that they are most often more about politics and governance than about constitutional design. And so I'm generally quite reluctant when people speak about constitutional change, if they haven't yet done the heavy lifting of going through the exercise and seeing, based on our existing framework, if what they would want to achieve could be achieved through our law as it stands. But the question that I've been thinking about recently, and maybe you can assist me on this with your views, given the depth and the persistence of these failures, is there a point at which systemic political underperformance itself becomes evidence of a constitutional design problem? For example, in our electoral system or our executive legislative relations, or in provinces exercising powers. And there I am particularly concerned with our current model of cooperative governance. Does it strike the right balance between national authority and meaningful provincial autonomy? Or is there a case for reconsidering the distribution of powers as part of a broader reform conversation? So essentially, my question is, how methodologically would you suggest we distinguish between what is fixable by better politics and what truly requires constitutional redesign? Thank you.
Bikezele, do you want me to give this, I'd say, 3 more questions? One is about whether we can call our constitution the rainbow book, like the red book in China. I don't know if you need to respond to that, but do you want me to give you the others?
Well, Carl asked two ones.
Okay,
Big ones.
you respond
May I
to that
just?
and then I'll give you the
Yes,
others.
I'll give very brief answers. I mean, Carl, the first one was whether we should have a law course in high school. I don't think so. I think there are ways and means that we should be already introducing constitutional concepts that are appropriate at different levels in the schooling system. I don't think that we should be teaching constitutional subsidiarity in grade 5. But we can be able to take some of the principles and articulate them in a way that makes sense to children at different levels of the schooling system. I mean, for me, my first introduction to the Bill of Rights and the Constitution was in primary school. And then that was in social sciences. And then we call it HSS, Human and Social Sciences. And that's where I learned about the Bill of Rights and what it means. And so I didn't need to be a constitutional scholar for me to really grapple with those concepts. Similarly, with government, we had a poster. Government used to print these posters called Faces of Government, where you saw all of the cabinet ministers. When we were speaking about cabinet in grade 4, we had that poster in our classroom. So there are different ways and means in order to introduce people to the core principles or the foundational elements of the Constitution without necessarily introducing a law course. And so that's one. And then the second one, the question about systemic underperformance being a failure of politics or the Constitution. I think it's a complicated question, and it's a long one, in the sense that, yes, there are some failures that are so systemic that they do speak to how our constitutional infrastructure is designed. You made an example of the electoral system, that we should be grappling with maybe changing the electoral system to allow for more direct elections or constituency-based models. But I don't have a real sense that solution or that proposal is properly diagnosed. I'm not sure if it is something that really comes from a serious grappling with why we are feeling this frustration that the political system is unaccountable. After all, our ward councillors are directly elected. And so that method is still not delivering the goods, what really should be the outcomes at local government level of having a member of your community representing you in the municipal council. We still haven't really grappled with that properly. But I do agree that there are certain of the constitutional design questions that we should be thinking critically about, especially 30 years on, right? 30 years is really a fairly long time for us to be sitting with the same structures. We should be thinking about whether it is time that some of those failures that we see are really as a design of the failure of politics and governance. We have numerous governance failures that we can point to, and maybe some people have heard saying we should abolish provinces because they are a waste of money, and we should have only district and national government as a proposal because that will make the schooling system better, for example. So I think there are debates back and forth, but I don't think that all of those proposals that are being suggested are really fully informed by proper diagnosis that they are really the cause of the problems that we see. So yeah, Kristen, you had a few questions.
Yeah, I think I'm gonna take the last bit of questions, so the one that are on here, Mbeki, and then you can respond, and then we'll just wrap up from there, if that's okay with you. Okay, so the one is around the question is the high volume of cases in the Crown Court a sign of the Constitution's strength or lack of clear legal language hindering the lower court's validity? Very interesting question. There's another one that says, what if those who have authority to initiate constitutional amendments are conflicted? For instance, in relation to the electoral system, if it's something that you're benefiting from as a member of parliament, is that something that you would initiate? I don't know what this question means. Did the Constitution protect the natural citizens for his integration, for his new society? Maybe I can just ask Solomon if you can just maybe rephrase that question, because I'm not sure we understand what that one means.
I think the question is, does the Constitution protect the naturalized citizen for his integration into the new society?
Okay.
And my answer is yes.
Okay. Okay, and then there's another comment from JJ, which is that there's no requirements for somebody to be a parliamentarian or member of parliament except that you are voted, your political party is voted for, and then obviously they can select who gets to go to parliament. But he says this has to be attended to as a matter of urgency. So that's more comment. So then the last question is just, why should South Africa still be obsessed with the land tenure system where title deeds reign supreme? Can't we have a different system of property ownership, given that the sovereignty of ownership of land, sea, and space lies with the state? So it's a question around the land system, around the conflict between being somebody who needs to initiate an amendment, and maybe you don't want to because it wouldn't benefit you or your party anymore, and then around the high volume of caseloads in the Crown Court.
Yeah, so Trisha, your question was whether the high volume at the Crown Court, high volume of cases at the Crown Court is a sign of constitutional strength or lack of clear legal language. Well, I think it's more of the Constitution's strength. Number one, the Constitution was amended in 2013 to make the Constitutional Court as the apex court in all cases. And what that meant is that every single case, almost every single judgment of the Supreme Court of Appeal now goes to the Constitutional Court. And that has meant that between 2010 and 2024, the volume of cases going to the Constitutional Court has almost tripled. And so that is one. But there's also a high volume of cases that are coming through what is called direct access or direct appeal, especially those involving the big, high-profile political cases that start off in disputes in Parliament, it goes to the Constitutional Court. And so that can be read as a strength in the sense that there are certain questions that have not really been properly defined in the Constitution, and they are making their way to the Constitutional Court for interpretation. For example, the impeachment of the president and what that looks like. I mean, we had the first case in what they call the EFF1 or the Nkandla cases, and now we are dealing with the Phala cases about what should happen to hold the president accountable under the Constitution. Those are novel questions that are arising, and they're adding to the volume of cases at the Constitutional Court because the Constitution itself it needs to be filled in through interpretation. And then the second question is, what if those who have authority to initiate constitutional amendments are conflicted? Whether I like to call this problem turkeys voting for Christmas. I mean, there is some truth to it, Sam, that yes, you won't find politicians voting in parliament to reduce their power or their influence, including in the electoral system. And so that's also, I think Kyle can give you a lot more information about that. But that is one of the key stumbling blocks to proper electoral reform, is that the insiders want to keep everyone else out. But I do think that as citizens, we have a responsibility to make noise and participate as the Constitution requires us to do. We have to really make sure that we bring a level of pressure, a level of maturity in Parliament, that when people are voting in Parliament or they're considering laws in Parliament, they're not doing so for themselves, their families, and their jackets. They are doing so for us as a society. And so when you're carrying out that sacred constitutional responsibility, you must do so with society in mind and not just yourself. It's not just self-interest. And that is something that we can inculcate as citizens and make demands of our politicians. So you're quite right that, yes, there is a conflict there, but we can overcome that conflict by us as citizens playing a more active role. And then the other question is that the requirements to be a member of parliament. I'd be interested, JJ, in what requirements would you set for you to be a member of parliament? Some people have suggested that you must have a matric, or you must have a higher qualification for you to be a member of parliament. I don't believe in that kind of thing, because if everyone who goes to parliament is someone who is university educated, we will have a parliament that speaks to certain class concerns and that will be blind to other concerns. And so you do need a diverse parliament. You need people with formal education. Yes, you need people with less formal education, but who have made a significant contribution in society and who can hold leadership responsibly. I think that is the most important thing. So maybe writing into the Constitution what holding leadership responsibly look like might help, but I think that is more of a political question rather than a constitutional question. And then the last question that you put forward was the land system and whether title deeds reign supreme. I don't think that our land system, and especially under the Constitution, title deeds necessarily reign supreme. The Constitution does recognize, for example, communal tenure. The Constitution does recognize customary rights under the law. Those rights are not necessarily based on title. They're based on custom, on people's traditions, and how they have evolved over time. And those are recognized by the Constitution. And something that is important that the Constitution does under both Section 39 and under Chapter 12, that it recognizes traditional or customary systems of law as being equivalent to the common law under the Constitution. That means that the rights to land that your community, if you are in some rural area of South Africa, those rights that have evolved over millennia or over hundreds of years, those are recognized just as much as those who have title deeds. So I don't think that some deeds are supreme, not under the Constitution at least.
Yeah, thanks, Mbekizeli. Oh, sorry, I thought I was muted. Thank you. And I think that last question and the way you've responded is super interesting. One of the things that I was thinking about in preparing for the webinar was around some of the legitimate concerns that are raised, but then are sort of monopolized in different ways. So in relation to the land question around, I know one of the things that are being put forward by certain parties at the moment is the idea of African traditional law systems as replacing a constitutional law system. And what is horrible about what that does is it takes away from the actual conversation and legitimate conversation that you can have around African traditional law systems and what that offers, because there are things. So you were speaking now about communal land rights and you know But even when I think about things, when I was a student at Wits, and we had to deal with the issue of family homes and how that isn't recognized, for instance, in any of our legislation explicitly. Those are things that we want to see incorporated into our law and into our frameworks, and it should be that way. But when you get a party, or like you were saying, populist influence that is calling for the overriding of the constitution by something like that, you start to question, what do I believe? Do I believe that these systems are good? Do I believe that they're not good? And so it leaves everybody a little bit confused. It's the same thing that sort of happened with the conversations around radical economic transformation. Things that we believe in and we know are necessary and good in order to get us to where we need to be. But then when it's hijacked, and then used for an ulterior agenda, it becomes, I think, more than anything, a little bit confusing to all of us. To all of us, about what we actually believe in and what we want to see happen, versus what is a populist technique for swaying votes, and nothing more. Um, and I
Yeah.
think that's what I've enjoyed. Sorry, yeah, go ahead.
Oh no, yeah, I agree with you. I mean, there are ways in which people have taken certain of the points to just extreme. I mean, look, there is an element where, yes, there is a legitimate frustration into how our legal system doesn't necessarily put the African legal systems or African traditional understandings of the law and incorporate them into the mainstream legal system. Sometimes it's because it is difficult, right? It is difficult as a judge who's been trained in a particular system of law to grapple with other
Mhm.
systems of the law. It's not
Mhm.
easy. Similarly for lawyers, I mean, sometimes I blame lawyers for not actually doing the research and bringing proper cases to court that will drive the kind of recognition or the kind of affirmation of traditional legal principles and infusing them into our mainstream legal system. It is not an easy job to do, and because it is a difficult job to do, most people shy away and choose the easy way out. The easy way out is often principles of Roman Dutch law, which are easily accessible. And so people really run to those versus trying to grapple with what actually does it mean to have a family home, which is
Mhm.
a communal piece of property that a family, not just an individual, has because of how the traditions and the customs of that family evolve. That kind of work really needs thinking and deep thinking that sometimes is what people tend to avoid.
Sometimes, Bekizele, when that thinking isn't not that the thinking isn't being done, but when that isn't happening at the scale that we wanted to over these past 30 years of the constitution, or of democracy, then it leaves gaps for other people to take a legitimate concern like that and then exploit it. And then we're faced with the sort of thing that we're talking about now, around whether it's just manipulation of a legitimate concern for your own gain, and or is it something the person or the party actually cares about? And I think I enjoyed that about your contribution, is just learning to be aware of um that nuance, I guess, that we need to be critical. And I agree with you, the constitution is not something to be all revered, and it's not all holy. And it's supposed to be dynamic and change to meet the needs of an ever evolving society.
Mm,
But at the same time, we need to guard against and be very critical, and able to quickly identify when something is being used for an ulterior purpose. And I think being able, as citizens, and as people living in this country, being able to spot the difference, is something we're going to all be needing to do. And yeah, yeah.
mm,
So thank you so much for providing your input on how you see things. Um, it would be lovely, I think, to have a follow-up session about practically maybe what people can do to do that spot the difference exercise.
mm,
Because I think that's something that anybody is grappling with, whether you're in the legal fraternity, whether you're involved in government, whether you are a person who's not involved at all in politics. But yeah, just to think about how we spot the difference, because I think it's becoming increasingly difficult for all of us in the country.
Yeah, no, you're quite right, Kristen. I think it is a difficult moment that we're in terms of our politics, our society, and the way that we as a society engage with each other and engage with information. But I think I would really encourage all of us to really try and grapple with these issues, right? For us to have a proper society, we do need to put in the work, right? We do need to be vigilant, eternally vigilant. We do need to be active, whether that activism is attending a webinar on a Thursday afternoon, or it is listening on the radio and calling in and giving a view on your understanding of these issues. That is all part of engaging with the issues and trying to remain critical. I mean, there's also resources available, in as much as I lamented that we don't have printed versions of the Constitution in Chivenda. There are online versions of the Constitution, and let's read them in the languages that we feel most comfortable. That is empowering of ourselves, and it helps us be more useful in terms of this engagement with our Constitution, because ultimately what, like I said, the Constitution envisages envisages for our societies that we are a vibrant, a free, a democratic, egalitarian society where all of us can live in full dignity, in having our dignity respected and affirmed. That is what the Constitution wants, and that is what all of us should be working towards. So I'd like to thank you again, Christian, and to the DoD team. Thank you again, and thank you for everyone who came and who have participated so vibrantly. I appreciate it.
Yeah, thank you, everybody. As Mbeki said, may we be internally vigilant. And as he said, being here on a Thursday afternoon is a sign of that. And I hope let's not tire. Let's not tire of doing the good work and the work that we are supposed to do, so that we can see the sort of society that our constitution envisages, in whatever sector that is and work that we're involved in. So thank you so much for being part of this, and I hope that you've enjoyed it. And look out for more invites from Defend Our Democracy for similar conversations. And we hope to see you at the next one. Thank you so much, Mbeki. It was really lovely chatting to you. Bye, everybody, and have a lovely, lovely evening.
Thanks, everyone.
Thank you very much.
Bye-bye.
I appreciate
you.
that indeed.
Thank you. Bye-bye.
Thank